Can you explain to me what intellectual property is?
Intellectual property protects your mental labor, okay? Your creations, your inventions, and your ideas that are expressed in tangible mediums. There's copyright, there's trademark, and there is patents. Copyright protects the expression of your ideas in a tangible medium. That means whatever you write down, whatever you capture in a recording, even a hologram, even nowadays choreography, movements can be recorded. Anything in a tangible medium is protected. Now, it doesn't protect ideas. Copyright does not protect ideas. Ideas are as free as the air. There's such a concept that we call in the law as the blurt out man. For example, you're in a cafe. You may be discussing something with a colleague or a friend, or even a business professional. Even if you're in a cafe and you're talking very loudly, the person next to you and the table adjacent hears what you're having, the conversation you're having, and it inspires them. And they go with whatever you were talking about, and they actually do create that piece of work. They have the rights to the copyright, all right? They have the legal rights because they actually underwent the labor to capture that idea in a tangible medium. It only protects tangible creations, copyright, all right? They have the legal rights because they actually underwent the labor to capture that idea in a tangible medium. It only protects tangible creations. Certain jurisdictions, such as California and New York, because ideas are very valuable in those industries, in those jurisdictions, the entertainment industries have developed another body of law based on court decisions, court precedent. They have developed what we called implied in fact contract, which is not based on intellectual property law, but rather based on contract law. And the key here, the main focus is that there must be a business setting. Now you're in a cafe talking, there's no auras of a business relationship there. You're in public. Now, if you were in private and you had arranged a meeting, there you have a better argument to say that you had a binding implied in fact contract and they could not use your idea. There's two other pieces of legal protection when we're discussing intellectual property. That's trademark, and that is patents. I do patent litigation. I don't do patent prosecution, which is the application process. You have to be a specialized attorney. But let's just say this in regards to patents. Patents protect inventions, processes that do not occur naturally in the environment. Anything in which there's an added element to the process, you can protect it with a patent. What I do practice is litigation. If someone has infringed upon your patent, I can sue them. I can prosecute them in the courts of law. Trademarks protects your brand. It involves commerce. It actually is a body of law which is meant to protect the consuming public so they can make quick buying decisions. So when they see a product and they relate that product to your brand, they know it's of good quality so they can make a quick purchase. That's the real purpose behind trademark law. So it protects your mark, which can be any indicia. That's trademarked, all right? Because it's unique and it's identifiable to that brand. Does that make sense?
Yes, it does.